The Trump administration has suffered a series of legal setbacks to environmental plans in recent days, further slowing its effort to rescind Obama-era rules and expand oil and gas drilling. A federal judge ruled Friday that President Trump's executive order to open up areas of the Arctic and Atlantic Oceans to oil and gas drilling was unlawful and exceeded the president's authority. Trump's executive order reversed an Obama-era ban on drilling in about 120 million acres in the Arctic Ocean and about 3.8 million acres in the Atlantic Ocean. Judge Sharon Gleeson of the United States District Court for the District of Alaska reinstated those rules, saying they will remain unless revoked by Congress. The ruling is a blow to the administration's efforts to expand offshore drilling. Former Interior Department Secretary Ryan Zink last year announced a plan to open up nearly all U.S. coastal waters to offshore drilling. Many state leaders have expressed concerns over the proposal. Acting Interior Secretary David Bernhardt last week said the plan is still in its beginning stages. For an administration rushing to expose nearly all our coasts to the dangers of oil and gas leasing, this court decision is a bright red stop sign, Neil Lawrence of the Natural Resources Defense Council, a plaintiff in the case, said in a statement. Judge Gleeson also ruled last week that the administration's plan to build an access road through a wildlife refuge in Alaska was unlawful. During his time as the head of Interior, Zink entered into an exchange of refuge land for private land with the King Cove Corporation to allow for the construction of a road through the Izembeck National Wildlife Refuge. Residents said the road would be critical for emergency access to the isolated community of roughly 1,000 people, but previous administrations rejected the idea, saying its construction would hurt the refuge's wildlife. Judge Gleeson ruled that it was illegal for the agency to change its policy on the proposal without proper justification. In a third case, Judge Louis Babcock of the U.S. District Court for the District of Columbia ruled last week that the Trump administration also broke the law by approving 2 drilling projects in Colorado. The Bureau of Land Management and the Forest Service did not adequately examine the indirect effects of the projects and failed to properly assess the impacts the drilling would have on mule deer and elk, according to the judge. The decisions are likely to be appealed. But taken together, they show a further slowing down of the administration's efforts to roll back Obama-era rules, says Robert Percival, an environmental law professor at the University of Maryland. It's a sign that they've been trying to move too fast, Percival said. Ultimately, it will make it take longer for them to accomplish their objectives. But the administration doesn't appear as if it's going to sit idly in the face of a string of legal defeats on policy issues. The president last week indicated that he is willing to get creative to avoid such challenges. Trump signed a presidential permit to grant permission for the construction of the long-delayed Keystone XL pipeline. A federal judge halted TransCanada's pipeline last year after determining the Trump administration had not adequately examined the environmental impact of the American Petroleum Institute cheered Trump's order. We applaud the administration for taking a no-nonsense approach to permitting this essential critical infrastructure project, API said in a statement. Percival said that any attempts to short-circuit the normal process will only create more delays. If they don't take a deliberate look at the environmental consequences, it will invite further legal jeopardy, he said.